all for the workshop on intellectual property rights and IP management for startup organized by Computer Engineering Department at MMIT Pune in association with Institutions Innovation Council. We are going to cover various points in this workshop related to IPR. First session will be on introduction to IPR and criteria of patentability, which will be covered by our eminent speaker, Advocate Swapnil Gawande. First session will be from 11 to 1:30, and second session will start at 1:30 up to 3 p.m., in which we will be covering topic content and drafting of patent application and IP management for startup, which will be delivered by Dr. Anil Turukmane, Professor, VIT AP. So, before starting with the actual session, I would like to introduce our first session speaker, Dr. Advocate Swapnil Gawande. We are fortunate enough to have him with us today for RPI workshop. Advocate Swapnil Gawande, sir, he is an intellectual property rights attorney with more than 15 years of experience. He is a founder and director of BLI Consultancy Private Limited, which is one of the leading IP law firm of India. He is a registered patent and trademark attorney and have filed and prosecuted more than 3,000 patent applications till date. He is a certified QMS lead auditor from Bureau of Indian Standards. He has formerly worked as adjunct professor and director of technology at incubation cell at IBSS Engineering College. He is an alumni and member of APIC Japanese Patent Office. He is presently working as a patent consultant for more than 200 educational institutions and industrial organizations globally. He is also acting as a trainer and has conducted various workshops for various institutions and organizations, including MSME, MCED, and Indian Patent Office. His expertise includes patent and IP, convincing prosecution, technology validation, and IP commercialization. I request Sir to please start with this first session. Thank you, sir.
Thank you, ma'am. So, very good morning, everybody. The session which I will be taking today is on intellectual property rights, and also we will look into patentability criteria in our session. So, as per our first session, in which we will be dealing about intellectual property rights, various types of intellectual property rights, and how exactly they are useful for every individual who is from academic background or who wants to start his own business or who is already in his business startup. So for this purpose, before moving towards the concept of intellectual property laws, we will go with a phrase. This phrase has been said by Josh Billings, and what exactly Josh Billings says? Josh Billings says necessity is the mother of invention, but IP right is the father. As the first part of this phrase is already famous, that necessity is mother of invention, but Josh Billing adds to that, but IP right is the father. Now, why exactly Josh Billing says this? We will take an example. I am working on a project from past 1 year. I spend my time, I spend my money, I take my efforts, I complete that project. After completion of that project, once I show the project to you, you straight away copy that project and bring that product in market. Will I be motivated again to start on another project? In this case, what will happen? In this case, definitely I'll be demotivated and I will never like to start on a new project. I will also try to copy paste some work and keep on working in same manner. Because reason is that if I'm not getting recognition for my efforts, I will never be motivated to work on that project. And there exactly intellectual property laws and IP right comes into picture. And and hence it is said that although necessity is the mother of invention, but intellectual property is its father. And when we talk about this intellectual property right, first of all, we need to understand the concept of property. When I talk about property in our legal definition, a right to use and abuse one's own within limits of law is a legal definition. But in simple word, anything for which I have having a legal document that this thing belongs to me or I am owner of this thing is termed as a property. And when we talk about this property is basically divided in two types. One is tangible form of property and other is intangible or invisible form of property. So tangible form of property in simple word means any property which you can assess by sensing that property. All those properties are called as tangible form of property. Whereas intangible form of property or invisible form of property is that which cannot be directly sensed to assess its value. All those properties are termed as intangible form of property. Like in regular use, if we take an example, if any one of you have dealt in share market, when I say that I hold 100 shares of Reliance Industries, that in simple word means that I am part owner of Reliance Industries because I am holding shares of those Reliance Industries. But based on those 100 shares, if I visit Reliance Industries and I ask them that I am holder of 100 shares, now show me part of your business which belongs to me as my ownership based on this 100 shares. No one can show me that part of that business which belongs to me, but those 100 shares in itself shows me are having a value, specified value, and they can show that there is a part of that industry that belongs to me as I hold those 100 shares of Reliance Industries. Same thing is applicable for intellectual property also. And to take a more simplified example to understand the difference between tangible and intangible form of property, if now I tell you that there is one interesting book relating to intellectual property rights which you must have. You go to a shop, you ask shopkeeper the price of that book. Shopkeeper tells you price of this book is 1,000 rupees. You pay 1,000 rupees to that shopkeeper. When you are coming down, suddenly you realize that this book is already there at your home and you don't need this book. But you don't want to climb up again the stairs and a Raddiwala is passing by. You ask that Raddiwala that you want to sell this book which you have purchased at 1,000 rupees. What price that Raddiwala will pay you for this book? Raddiwala will hardly pay you 1 rupee or 2 rupee for that book. Now issue arises, just 2 minutes back, you have purchased a book at the price of 1,000 rupees and Raddiwala is quoting the price of same book at 2 rupees. So what happened between these 2 minutes? So that price of that book was drastically reduced from 1,000 rupees to 2 rupees. Actually, reason is not that book. Reason is book is a property and two people are looking at the same property but in a different way. When Raddiwala is looking at that book, he is looking only at its tangible form. That is from what material that book is made, what is weight of that material. And based on its tangible form, Raddiwala has assessed price of that book as 2 rupees. But when you purchase that book, did you ask the shopkeeper to first weigh that book before purchasing? No, because you purchase that book based on its intangible or invisible form. That is, what is the subject on which that book is written, who has written that book, what knowledge that author holds on that subject, based on which you paid remaining 998 rupees for that book. And that exactly is power of intangible form of property, which can convert a 2 rupee tangible property into a 1,000 rupees intangible form of property. So that exactly is a basic difference between tangible and intangible form of property. And when we talk about intellectual property is part of that intangible form of property. So what exactly is this intellectual property? Intellectual property, in simple word, means any property which you create using your intellect, or any property which you create in whose construction the primary tool was your brain. All those properties are termed as intellectual properties. Like we can take an example, during at the time of working on any project or while preparing our project, what exactly are the requirement? First thing is that you may need raw material, you may need spares, you may need the PC, papers, pen, all these things are required. But if I give all these things to any layman, can he work on your project? No, because the primary thing which will be required for that project will be, you have to apply your intellect. You have to think on which project I want to work, how I will work on that project. When you will be constructing a prototype, at the time of prototype development, when any problem comes, you will have to think how to solve that problem, how to overcome that problem. You will have to collect scientific database. You will have to evaluate. You will have to calculate all those things. So what exactly is a thing? The primary tool which is working to complete that project is not the raw material which is required for that project, but the primary tool which is required for completion of any project is your brain, your intellect. And all those properties which are created from your intellect are termed as intellectual property. Now, this intellectual property, we need to understand why exactly intellectual properties need a protection. The first reason for granting protection to intellectual property rights is it provides a mechanism to legally protect the creativity. Until and unless there is no legally mechanism which can protect creativity, person will not be motivated to innovate new ideas or to innovate new things. So it provides a legal mechanism to protect and to protect creativity. Another thing is that it promotes the creativity by providing incentives for protection. Incentives of protection. Like when I am working on any idea, if I convert that idea into my property legally, I can sell that idea, I can license that idea. If it's a book which I have written, I can publish that book, I can ask for inventor royalty. I will get a legal recognition that this research paper, this book was written by me, and no one can copy that research paper or that book. All these things are the incentives which a person gains by way of this intellectual property law. So it provides incentive and promotes inventor to invent new things. And third thing is that it provides a mechanism and assurance to reader and customer in that the thing which they have taken, they have obtained is original work and is coming from original source. So intellectual property is not only for inventors or creators, it is also for customers. That the thing which I am purchasing, that thing is a original work. It's not a copy paste material or it's not a plagiarized material. So this assurance is provided to reader or to a customer that the thing which he is gaining is a original work, a work of originality. So for all these purposes, the concept of intellectual property laws emerged. And when we talk about these intellectual property rights, these intellectual properties are basically divided in two types. One is industrial property and other is artistic work. Under industrial property, again there are multiple intellectual properties like patent, trademark, industrial design, geographical indication. And under artistic work, there is only one type of intellectual property, and that is copyright. Now, we will briefly understand what exactly this multiple intellectual properties refer for, and then we will individually understand what this individual intellectual property law is. So, first type of intellectual property is patent. Whenever I am inventing anything new, and if I wish to protect that invention, all those inventions are protected by way of patent. So, to understand that, we will take an example of mineral water bottle. There is one mineral water bottle available in market, and that mineral water bottle is Oxyrich. Oxyrich is manufactured by Manikchand Aqua, and if you see bottle of Oxyrich or advertisement of Oxyrich, in advertisement of Oxyrich they say हमारे पानी में है 200% ज़्यादा ऑक्सीजन or our water contains 200% more oxygen. And even if you look at the bottle of Oxyrich, on that bottle it is written added oxygen. If you look at bottle of any other brand, say Bisleri, Aquafina, Bailey, or any other mineral water, they will never write added oxygen on them. Only Oxyrich adds added writes added oxygen. Now, why exactly this happens? Because if you look at that bottle, on that bottle it is written patent protected technology. That means Oxyrich has developed a technology with the help of which oxygen content in water can be increased. And they have protected that process by way of filing of patent application. So until and unless that patent is nullified or that patent gets expired, no other person can add oxygen in water and sell it in market. They will be holding monopoly on that invention. So whenever you are inventing anything, and if you wish to protect that invention, all those inventions are protected by way of patent application. Second type of intellectual property is trademark. Trademark basically protects the identifier. Now, how exactly trademark protects the identifier? Whenever as a customer, I go to a shop or purchase a product, what I look what is name written on that product. And when I look at the name written on that product, that means an impression comes in my mind that this product has been manufactured by some X company. If I give you an example, if I give you an example that if I put two mineral water bottles in front of you, one is Pepsi, one is Bisleri, and other is Hariganga. Which bottle you will purchase? Obviously, every one of you will pick bottle Bisleri, and you will not pick Hariganga. Now, why exactly this is happening? Because Bisleri has created a mark in your mind that quality of this product is assured. And that is why obviously everyone will pick Bisleri apart from Hariganga. Now issue arises if every one of you knows that if label of a product is kept as Bisleri, sale can multiply to any extent. Why Hariganga person is not putting label of Bisleri? Because Bisleri is registered trademark of Parle Agro. Parle Agro has protected the name Bisleri of in their brand name so that no other person can put label of Bisleri on their product and sell it in market. So what exactly is happening? Trademark is granted for any identification mark based on which customer can identify that the product or services which I am taking, what exactly is source or origin of those products or services. All those identification marks are protected by way of trademark application. Next type of intellectual property is industrial designs. Many times when we are working on a project or we are developing a product, there might be no invention or innovation in mechanism of that product, but that product looks different and that look of that product is unique. In that case, if you want to protect how your product looks, all those looks of that product are protected by way of industrial design application. For that also we can take example of a mineral water bottle. There is a 300 ml mineral water bottle of Bisleri. It is having a dew shape, and you will find no other bottle with that shape in market. Why exactly no other bottle with that shape is there in market? Because shape of that bottle is protected by Bisleri by way of Industrial Design Act, so that no other person or company can copy that shape and sell their product with in bottle of that shape. So whenever your shape, structure, and configurations are unique, those are protected by way of Industrial Design Act. Next type of intellectual property is geographical indication. The previous intellectual properties which we saw, that is patent, trademark, industrial design, all these properties are individual rights. Like if I am inventing something, I'll be filing a patent application. If I am designing something new, I'll be filing a design application. If I am having a business and I have given a name, a logo for the developed a name or logo for that business, I'll be filing a trademark application. But geographical indication is only type of intellectual property which is never about an individual. It is always about a community. So geographical indication is basically granted for any product which is specialized because that product is manufactured in a specified geography, which is famous because of that geography. All those products are protected by way of geographical indication, like Nagpur oranges, Nashik grapes, Kolhapuri chappal, Solapuri chaddar, Puneri pagdi, the Mahabeshwar strawberry, all these products are protected by way of geographical indication. Next type of intellectual property is copyright. Copyright covers all type of artistic works, like whenever you are writing a research paper, whenever you are writing a book, poem, musical composition, YouTube video, educational video, all those things, or even the presentation which is in front of you, all these things are protected by way of copyright. So now individually we will understand how this different intellectual property works and what impact these intellectual properties can create on any product. For that purpose, we have taken example of a brand Evian. Like other mineral water bottles, Evian also sells water in market. But the difference of Evian is the price in which Evian sells. If I want to purchase a bottle of 500 ml bottle of Bisleri or Aquafina, it is available at the price of 10 rupees, 15 rupees. But if I want to purchase 500 ml bottle of Evian, the starting price of bottle of Evian is 650 rupees for 500 ml. That means 1300 rupees liter is starting price, and which goes to around 10,000 rupees liter. Now issue arises, why a person will spend 1300 rupees for a liter of water if it is available with other reputed brands at the price of 20-25 rupees. The issue lies behind the multiple intellectual properties which brand Evian holds in itself. Now, the first intellectual property which is there in this brand Evian is copyright. How copyright is there in this brand Evian? The image which you are looking, you will see that different designs are drawn on this bottle of Evian. Like on right hand side, a penguin is drawn and various bubbles are drawn. If you come at other side, there is a different design structure drawn. In center, a eye is drawn and various bubbles are there. On left hand side, mountains are shown. What these things are showing, Evian hires world's renowned designers and they draw a specific design on their bottle with name of that designer, so that whenever a person is purchasing a bottle, a unique design of that world renowned designer is drawn on that bottle, so which makes that bottle collectible item even when that bottle is empty. So first intellectual property which is there in this bottle of Evian is copyright, that is design which is drawn on this bottle. Second intellectual property which is in this brand Evian is brand Evian itself, which trademark is protected in 150 countries globally. So that wherever in the world I am traveling, if I am purchasing bottle of Evian, I am 100% assured that the bottle which I am getting is originally manufactured by Evian itself. So its international trademark protection of brand Evian is second intellectual property which Evian holds. Third intellectual property is patent. Now, how there is patent in this bottle of Evian? Like in Oxyrich, water was holding patent that they have added oxygen in water. But in case of Evian, patent is not in water, but the patent lies in bottle itself. The bottle of Evian is manufactured from 100% decomposable, environmental friendly polyethylene material. So this material doesn't cause any kind of harm to environment, as well as when you are consuming water from this bottle, it doesn't cause any type of harm to your body also. So next intellectual property which is there in this bottle of Evian is patent. That is 100% decomposable polyethylene material from which this bottle of Evian is made. Next intellectual property of this bottle of Evian is industrial design. How industrial design is there? You look at shape of this bottle. Shapes of these bottles are protected by way of industrial design application, so that no other person can copy shape of of these bottles. So shape of the bottles are protected by way of industrial design application. Next intellectual property again in bottle of Evian is geographical indication. How geographical indication is there? If I purchase a bottle of Bisleri in Pune and I purchase a bottle of Bisleri in Delhi, water in both the bottles will be different. Because in Pune, the water which will be there will be collected from bottling plant in Pune, and in Delhi, the water which is there in Delhi, the Delhi Bisleri bottle will be collected from bottling plant which is located in Delhi. But in case of EVR, this is very difficult for an international traveler, because in any country I travel, every time my water changes. And for an international traveler, it is very important that his water always remains constant. Like if people like Virat Kohli, Amitabh Bachchan, or businessmen like Ambani, Adani, for them, having a constant water source always is very important. What Evian does, in Italy under Alps mountains, there is a specific stream which is having high mineral and antioxidant contents with them. And Evian has purchased that whole stream and taken geographical indication for that stream. And whatever water is bottled in Evian bottle and sold anywhere in the world comes from that stream only. And that exactly is the reason, or another intellectual property which is there in bottle of Evian, that is geographical indication, the water which is packed in bottle of Evian. And when you merge these multiple intellectual properties in single brand, you can even sell water at the price of 1300 to 10,000 rupees liter. And it is not necessary that you must have a plant, you must have a plant in Italy or any other country. Even Bisleri has launched its new brand, that is Ava. And that Bisleri brand, which they have launched, they collect water directly from Himalaya mountains. And the price of that bottle is 80 rupees. Why Bisleri is selling that water at the 4 times price? Because it is holding geographical indication with them. So when you merge these multiple intellectual properties in any brand, you can sell the product at any price. So this exactly is power of these intellectual properties. And it is not just restricted to bottle. You can take any example. Like the basic example which we can take is of salt. You go on India Mart website and search for white loose salt. White loose salt is available on India Mart at the price of 80 paisa per kg. But when you go to a shop, have you found a salt at the price of 80 paisa kg? Or even if you pack that salt, the package, and we consider packaging charges at 1 rupee, whether salt is available at 2 rupees in market? No. They have to, even if we go for basic brands of the salt like Gai Chap, they are available at the price of 7 rupees or 8 rupees per kg. Now, why exactly price is multiplying? Because when I pack a product, put my brand name on that product, immediately price of that salt jumps around 8 times. Again, if I go for Tata salt, I am only changing brand name, but salt is salt which Gai Chap is selling. Immediately 8 rupee kg salt jumps to 16 rupees per kg. Again in Tata salt, when I add a word Tata salt light, that means low sodium salt. That means I have developed a technology with the help of which sodium content in salt can be reduced. Immediately when technology or invention is added in that salt, again price of that 16 rupees kg salt jumps to 32 rupees kg. Now issue arises, the starting price of white loose salt was 80 paisa per kg, and now it has jumped to 32 rupees per kg. This exactly is power of intellectual property, and you can take any example and everywhere around you, you will find these examples, which the way in which intellectual property can change any kind of business. Now, the first type of intellectual property which we will be discussing now is trademark. Now, what exactly is trademark? Trademark in simple word means, trademark means any word, any phrase, any symbol or design or a combination of these things which identifies and distinguishes the source of goods or services of one party from other. All those identification marks are termed as trademark. Like we can take example like word, whatever words are written on it: Parley, Crackjack, Britannia, Ghadi, Pepsi, Coke, Colgate, Ved Shakti. All these things are the words which are protected by those individual companies by way of trademark application. Even phrases are protected by way of trademark application, like मेरा सपना मेरी मारुति, पहले इस्तेमाल करे फिर विश्वास करे, just do it. All these are phrases which are also protected by way of trademark application. Even symbols are protected by way of trademark application, like just a red color tick mark. image of Nike comes in our mind. A yellow color M. I am not writing anything. I am only showing a yellow color M. Immediately McDonald's come in our mind. Or even a color combination. A circle having red, white and blue color in it. That circle is protected. That design of that circle is protected by Pepsi. Or a T which is written, which shows the logo of Tata. So all these things are different symbols based on which customer can identify what exactly is the source or origin of goods or services which I am taking. All these identification marks are protected by way of trademark application. Even there is one Norwegian company which is a garment manufacturer. What exactly that company has done? That company sprays a specific fragrance on their garments. And their claim is, even when a blind customer will enter a shop, just by smelling our garment, he will come to know that this garment is manufactured by our company. So a specific fragrance on a garment is protected by that company by way of trademark application. So trademark can be any identification mark. Now, when we talk about this trademark, in trademark application, we need to know that it is not that when I am filing a trademark application of my firm BLI Consultancy Private Limited, that means no other person can use the word BLI. The trademark application which is filed at trademark office, there are total 45 different classes. And the class in which you have filed trademark application, you get protection only in that specified class. Those 45 classes are divided into those 45 of those 45 classes, 34 classes are provided for goods manufacturers and 11 classes are provided for service providers. So these are different classes. First of all, we need to identify the business which I am doing, in which class my business belongs. And then we need to file trademark application. If your business belongs in multiple classes, you can file multi-class trademark application also, or you can file trademark application in all 45 classes also. But you will get protection of trademark only in the class in which you have protected your trademark. So that is a classification system. And where to file a trademark application? In India, these trademark applications are filed in 5 offices. The trademark office comes under Controller General of Patent Designs and Trademark, and trademark registry is located at 5 places: Delhi, Mumbai, Chennai, Kolkata, and Ahmedabad. And you cannot file trademark application in any of these offices. The place where you are doing business, only in that region you can file your trademark application. Like Maharashtra, Madhya Pradesh, Goa are covered under Mumbai trademark registry. So any business which is carried out in these states has to file trademark application before trademark registry Mumbai. Next type of intellectual property is industrial designs. Now, what exactly is this industrial design? For that purpose, there is a phrase of Don Norman. What Don Norman says, it is not enough that we build products that function, that are understandable and usable. We also need to build products that bring joy and excitement, pleasure and fun, and yes, beauty to people's life. Like when I am working on a project in my college, I complete that project. Does that project become sellable immediately? No. Because when you are working on a project, although your product might be usable, which you have developed, it might be performing a function, but I as a customer will never like to bring that prototype at my house for working. I will always look at a beautiful looking product. And that exactly is a reason whenever we are inventing anything, we must not just concentrate on the working of our product, but we also need to look at how our product aesthetically looks, because that is very important factor in customer's mind if you are planning to commercialize your invention, without which commercialization of invention is practically very difficult. So when we talk about this design or the shape which we have given to product, obviously if I have invented something, I will protect that invention by way of patent. But how my product looks, that effort which I have taken to give a unique look to my product so that customer will be attracted to purchase my product. Obviously, I will like to protect the look of my product also by way, and the way in which I can protect that look, that way is provided to me legally by way of industrial design application. So when we talk about this Industrial Design Act, first thing is that we must always keep in mind the rules which are applicable for design are similar to the rules which are applicable for patent application. So the rules of novelty is also applicable in case of design application. Another thing, like in patent application, design is also a statutory right. Until and unless you have filed a design application and that design is protected on your name, you will not get any kind of protection on that design. So first thing is that design is a statutory right. Until and unless you protect that design on your name by way of filing of design application, you will not get any kind of protection for your design. Another thing is that the right to prevent all others from producing, importing, selling, or distributing product having an identical appearance or fraudulent or obvious imitation. That is right which is provided by Design Act. Monopoly is for a period of 10 years, which can be again be extended for a span of 5 years. So life of design application is 15 years. It gives you a unique selling point, and it is an asset which can also be licensed. Now, what is criteria for design registration? If you want to protect your design application, what exactly is the criteria? First criteria for design registration is finished article appeals to and is judged solely by I. If just by looking at your design, I cannot assess that this design looks different or this design is different compared to other designs which are available in market, that design cannot be protected by the design application. So just by looking at that product, I must be capable to understand the distinguishing features of your design compared to other designs which are available in market. That is the primary criteria. Another criteria is the
ये
design
निकाल दो
has
इसका कवर, ये पूरा निकल का।
someone's mic is on, I think. Another criteria of design registration is originality. Originality means until and unless you file design application, you must not bring your product in market. So novelty or originality is another criteria. Not prior published in any country and not publicly known in India. That design must not be in public domain. Is significantly distinguishable from the known design or combination of known designs. Like if we take an example, this is a design of bottle which is having different grooves. If I just change angle of those groups to certain extent, although design will change, but it will not create a significant impact on that design. And just by changing slightly the angle of design, I will not be creating a new design and it cannot get protection under design set. And the most important thing is not a technical or useful function of the product. If you want to protect technical or useful function of your product, you will have to file patent application. It will not be protected by way of design application. If I say that these grooves are having a copper lining because of which the quality of water will improve, that will not be protected by way of design application. Only because of adding of copper linings, the looks of bottle are changing. Only those looks can be protected. The material which is added, which is incorporated, those things will not be protected by way of design application. Another thing, exclusions, things which cannot be protected by way of design application. Design primary literary or artistic in character, like books, calendar, certificate, forms and other documents, greeting cards, leaflets, maps, plan cards, postcards, stamps, medals, label, token, cards and cartoons. All these things are treated as literary work, and if you wish to protect these things, you need to take protection under Copyright Act, and you cannot protect these things by way of design application. Next thing, any principle or mode of construction of an article. How I have constructed this bottle, what materials I have used in construction of this bottle, these things will not be protected by way of design application. Mere mechanical contrivances which are created because of which are created, those will not be protected by way of design application. Buildings and structures, civil engineering structures, those are not protected by design application. Parts of articles not manufactured and sold separately. If I have developed design of this bottle, I cannot file protection for this cap because this cap will never be sold separately in market. This cap is always part of this bottle. So any part which cannot be separately sold in market cannot be protected by way of design application. It has to be a whole product. Next, variation commonly used in trade. If you have just made slight variations in use, which are used in trade, those variations cannot be protected by way of design application. And mere workshop alteration of component of an assembly, that also cannot be protected by way of design application. So these are the exclusions or things. If your design is falling under this criteria, it cannot be protected by way of design application. Now, the scope of design application. Design is almost applicable everywhere where you see. Like when I go to to cloth shop, the person says that price of this shirt is 3,000 rupees. I say, अरे 3,000 तो बहुत ज़्यादा हो गए. Similar shirts are available at the price of the 800, 900 rupees. He says, sir, this is a designer wear. When the word designer wear comes, in case of sari, lehenga, or any kind of thing, that means that design is protected by that designer under Industrial Design Act, and only they are authorized to sell that design. So it is applicable. You take any industry, everywhere design will be applicable. Like in customer product, bags, bottles, scissors, your press, wallet, watches, everywhere, chappal, shoes, pen, everywhere design application is applicable. Even in pharmaceuticals, how those inhalers look, how those injections look, the way in which bottles are manufactured, color combination of the medicines, all these things are protected under industrial design application. Even in textile and jewelry, Design Act is applicable. Now, where to file a design application? Design Office also comes under Controller General of Patent, Designs and Trademark. Its head office is located in Kolkata and branch offices are in Delhi, Mumbai and Chennai. So wherever your jurisdiction falls, initially we need to file, we had to file design application only at Design Office Kolkata. But now you can file at any of the respective design registry offices of, that is Delhi, Mumbai, Chennai, Kolkata. Next type of intellectual property is geographical indication. Now, when we talk about this geographical indication, what exactly this geographical indication is? This is a map of various products which are famous as per the specified region of India. And all these products are protected under Geographical Indication Act. So when we talk about this geographical indication, what exactly is this geographical indication? Geographical indication is an indication which identified goods as agricultural good, natural good or manufactured good. So only these three type of goods can be protected by way of geographical indication. One is agricultural good, other is natural good, and third is manufactured good. So your product must fall under one of these categories, and originating or manufactured in territory or country or region or locality in that territory, where the quality, feature and reputation of such good is significantly attributed to its geographical origin. Whenever any product is famous because of a geography in which that product is manufactured, all those products are protected by way of geographical indication. But the important criteria is that a premium has to be associated with that product with the name, because of the name of that geography. And that exactly is important in case of geographical indication. Now, what exactly is property in geographical indication? GI product through GI produced through traditional process that involves least or no industrialization. Premium associated with most of this product because of its geography. The property in GI that need protection is this premium, which is nothing but collective goodwill enjoyed by all its by all its producers. So this exactly is the property which is related to geographical indication. And we can take a simple example of Rasgulla, which created a huge controversy few years back in India. Why this controversy happened? Because West Bengal filed application for protecting Rasgulla under geographical indication with the name of Bangalore Rasgulla. And when this GI was registered by Geographical Indication Registry, Odisha went to High Court to revoke this GI application, claiming that Rasgulla basically originated from Odisha. and Bengal cannot claim geographical indication registration for Rasgulla, but this application was rejected by High Court. And why this application was rejected? The reason behind that was that Bengal had clearly identified differences of their Rasgulla compared to the traditional Rasgulla which was manufactured in Odisha. Like, the first difference was least hardness. The Bengal Rasgulla had least hardness compared to any Rasgulla which was traditionally manufactured anywhere in the world. Next was cohesiveness of that Rasgulla, which shows smoothness of that product. Next is lower chewiness, suggested soft texture, and Gia is not for the word Rasgulla but for the word Bangalar Rasgulla. So if you want to label Bangalar Rasgulla on your the product, you only have to start a manufacturing unit in West Bengal. Any food manufacturer who is not having manufacturing unit in West Bengal can put label of Bangalar Rasgulla on his product name. That exactly is power of geographical indication. Now, next type of intellectual property is copyright, because copyright is very essential for every academic, very essential for academic purpose. So, when we talk about this concept of copyright, we need to understand what exactly this copyright means. For that purpose, to understand the concept of copyright, the definition of copyright is a protection that covers published and unpublished literary, scientific, and artistic work, whatever the form of expression, provided such work is fixed in a tangible or material form. So, to get a copyright protection, it is not necessary that that work has to be published only. Even for unpublished work, you can have a copyright protection. Copyright protection is allowable for published as well as unpublished work. But the published or unpublished type of work, that work has to be brought down in a tangible form. And until and unless it is brought down in a tangible form, it will not get a protection. Like, if I want to claim a copyright protection for a painting, I have to draw that painting on a paper. If I have to claim copyright protection for my research paper, I will have to write down that research paper. If I am having idea that how I will be developing a unique software, that idea cannot be protected by way of copyright application. I will have to develop that software, and when it will come into a tangible form, because when I am developing a software, that codes, I can take printout of its source code, as well as it is protected and it comes in tangible form in a hard drive. So until and unless I develop that software, I cannot claim copyright protection. So it can be published or unpublished work. It can be of any form, but it has to be brought down in a tangible form. Until and unless that work has been brought down in a tangible form, it cannot get copyright protection, and hence there is no copyright protection for an idea. Idea cannot be protected by way of copyright. Now, what are the four factors of fair use in relation to copyright? In case of copyright, if I am using copyright of some other person, in that case, whether I am doing a criminal breach of copyright or not, for that purpose, four factors will be taken into account by the court. The first factor is the purpose and character of the use, including whether such use is of commercial nature or is of non-profit educational purpose. This is the primary criteria, because of which, if there is a book, I have taken some printout of some pages of that book for teaching purpose in my classroom. That is a pure educational purpose. That will not be treated as infringement of copyright if I am purely using that copyrighted work only for teaching purpose. But if I have taken printout of those books and I am selling those printouts to my students, in that case it will not be an educational purpose, it will also be a commercial purpose, and it will not get protection under it will not get protection as educational use. Next is nature of copyrighted work. The person who has created that copyright brought down that copyright into a tangible form. What exactly is nature of that copyrighted work? I have written a research paper, nature is different, because I have not written a research paper to sell it in market. But if I have written a book for circulation and selling in market, its nature of the corporate completely changes. Next thing, amount and substantiality of the portion used in relation to copyrighted work as whole. If I have used just some part of that book, or I have copied significant part of that book, those things will also be considered at the time of understanding the extent of infringement. Infringement is there in both the cases, but to understand the extent of infringement of copyright, these things will also be considered. And another thing will be effect of use upon potential market for the value of the copyrighted work. What impact my infringement will be creating on the original product will also be considered to understand copyright infringement. And always keep in mind, copyright is not just a civil offense, it is also a criminal offense. So a person infringing copyright of some other person can also be prosecuted criminally. And that exactly is a reason we need to take extreme care when we are infringing copyright of some other person. Another thing is that copyright holds international protection under Bern's Convention. So even if a person sitting in USA has never came to India, has never applied for copyright protection in India, still that person holds all the right a copyright holder holds in India, even if he is sitting in USA. So copyright is having an global international protection. That is biggest advantage of copyright, which is not available with any other type of intellectual property, a automatic international protection, which a copyright application holds under Bern Convention. So what are different types of copyright? Literary work like books, pamphlet, poem, articles, letters, tables and compilation, computer programs, all these things are protected by way of copyright. Even dramatic works like recreation, cinematographic work, dumb shows, flashcards, scenic arrangement, as well as acting is protected by way of copyright application. You might have heard few years back there was a character which used to come in Kapil Sharma show. It's a famous show which comes on Sony TV. In that Kapil Sharma show, there was a person, actor Sunil Grover. He used to play character of Guthi in that Kapil Sharma show. After some time, Sunil Grover left Kapil Sharma show and he approached Z Television. And he wanted to act same role of Guthi at Z Television. But Z Television were having doubts about that character. So what they did, Z Television during their during the Z Cine Awards, they asked Kapil Grover to perform the character of Guthi for 5 minutes. And when Sunil Grover came on stage, they had changed the name of Guthi to Kuthi, Kutthi. But immediately Z Television received legal notice from Sony Entertainment Television, claiming that although the character of Guthi was performed by Sunil Grover on the stage of Sony Television, but the character of Guthi is copyright of Sony Entertainment Television. We can bring any actor and ask him to perform role of Guthi, but Sunil Grover cannot perform Guthi apart from Sony Entertainment Television. So that exactly is power of copyright. And even in musical work, there are copyrights which are there. In artistic work, painting, sculpture, drawing, diagram, cartoon, map, chart, plan, engraving, all these things are protected by way of copyright application. Even in artistic work, when you look at the packaging of the packagings, like in Tata Salt, a girl and boy are running on a white road. The whole picture is protected by way of copyright application. All these things are protected. And in case of copyright, what rights the author hold? The author holds two rights in case of copyright application, which is not available in any other type of intellectual property right. In any other type of intellectual property right, like patent, trademark, industrial design, geographical indication, only one right is available, that is economic right. This economic right is available in case of copyright also. That is reproduction, publishing, performance, communication to public, adaptation, translation, transliteration, rental, assignment. All these rights are available in case of copyright also with the author, but author holds one other very significant right apart from economic right, and that right is moral right. What exactly this moral right is there? In case of moral right, even after the author has sold copyright of his copyrighted work to some other person or publisher, if that person is making any changes in that copyright, without author's consent, that is treated as breach of moral right of that author. We can take a famous example of a Marathi movie, Duniadari in this case. The Duniadari was inspired from a book which was written by one author. Based on the producer of movie Duniadari had purchased rights of that book to make a film on that book from that writer. But what happened when producer purchased right of that book? When they had a sitting with director, it was asked that the end of that book has to be changed to make a successful movie. But when they approached the writer straight away rejected their request. And he said that if you want to make a film on my book, you will have to make the film as it is. And no changes can be made in that film. For that purpose, for years, that project was lying idle. But after some time, unfortunately, that author died. And after death of that author, his family members gave permission to producer to make a film by making any changes required. And only after that, that movie Duniadari was able to be produced. So that exactly is a power which copyright holds, which is commercial right or economic right as well as moral rights, which are not available in any other type of intellectual property rights. And where to file copyright application? As in other intellectual property rights, copyright registry is only one. Copyright registry is located in Delhi, and all applications pan India are to be filed before Copyright Registry Delhi. Now they have merged Copyright Registry under Controller General of Patent Designs and Trademark, but still that registry is single, and all the copyright applications are to be filed before Copyright Registry Delhi. And another aspect which we need to consider to understand more about copyright is the difference between copyright and plagiarism. When we talk about this copyright as well as plagiarism, we need to understand what exactly is the difference between copyright and plagiarism. Because many times we think whatever I have done is not infringement of copyright, that means I am safe. So we need to understand just by not getting into copyright infringement doesn't mean you are safe from the aspect of plagiarism. For that purpose, we need to understand the difference between copyright and plagiarism. Basically, as said earlier, copyright is a protection that covers published and unpublished literary, scientific, and artistic work in whatever form it is. Copyright is a legal misconduct that you are committing a legal offense and hence you will be prosecuted legally. But plagiarism is not a legal misconduct. Plagiarism is treated as a serious scientific misconduct. What exactly is meant by plagiarism? Plagiarism is a practice of taking someone else's work or idea and passing them off as one's own. In case of copyright, I know that this book is written by one person. I'm copying that book and selling that book in market. But in case of plagiarism, it is not important that you are copy pasting from some other person's source. It is important that you are showing that whatever some other person has done, that work has been done by me. And hence plagiarism, the meaning of this Latin word plagiarius is to kidnap. And when someone uses the work of other artists without properly citing the source or giving proper credit to that artist, then that work is treated as a plagiarized work. And it is intellectual theft and a scientific misconduct. So this is a basic difference between copyright and plagiarism. And when we talk about plagiarism, in case of copyright, we have seen that the purpose, all these things are important. But in case of plagiarism, for whatever purpose you might be plagiarizing the work, what your intent is, what the source is, what the quantity in which the work has been plagiarized, or whether that work is copyright protected or not, all these things are completely irrelevant. Plagiarism is plagiarism. So these factors will not come into role in case of identifying whether you have plagiarized the work or not. And another thing is that in case of copyright, if we take example story of Romeo and Juliet. In Romeo and Juliet, what happened? A rich girl, a poor boy, both fell in love. Their family members were against it. End of the day, they both died. Have you ever heard this story? There are hundreds of Indian movies made on this theme. But every movie created a new copyright because the idea was the same, but the way in which that idea was expressed, that idea was different. And hence, every writer created a new copyright on his new film or on his new write-up. But this rule is not applicable in case of plagiarism. When we talk about plagiarism, mere changing few words from here to there will not keep you out or will not create an escape route for you in case of allegation of plagiarism. For that purpose, we can take a simple example of Melania Trump and Michelle Obama. When Donald Trump became president, Melania Trump in 2016 gave a speech. In her speech, she said, "From a young age, my parents impressed on me the value that you work hard for what you want in life, that your word is your bond and you do what you say and keep your promise, that you treat people with respect." This was the line which was said by Melania Trump in 2016. But immediately she was accused for plagiarism. And why she was accused for plagiarism? Because when Barack Obama became president in 2008, Michelle Obama gave a speech. In that speech, Michelle Obama said, and I were raised in so many of the same values, that you work hard for what you want in life, that your word is your bond and you do what you say you are going to do, that you treat people with dignity and respect, and even if you don't know them and even if you don't agree with them. Now, if you look at these both paragraphs, copyright, in case of copyright, it is under no circumstances a copyright infringement, because what Michelle Obama had said, Melania Trump had completely reworded those phrases, but she was still accused of plagiarism, because you can easily understand what Michelle Obama had said. The sentence of Melania Trump was completely inspired from that, and hence Melania Trump was accused for plagiarism in this case. So this is the actual difference between copyright and plagiarism. So whenever you are writing any research paper, whenever you are writing any thesis, always keep in mind, give recognition or add indent mark on each and every line and identify the source or origin of each and every line. Even if you mistakenly provide source to some other previous author who is not the original author, that will also be treated as plagiarism. So whenever you are taking line from any other author, it is your responsibility to identify the original source of that line, and only after that you can use that line. If you have quoted a wrong author for that line, that will also be treated as plagiarism. So that is very important in case of plagiarism. So I think, ma'am, we must take a break of 5 minutes and then we will move.
Okay, sir.
Then we'll move towards our next topic, will be patent. In that, we will understand what exactly patent is, what things are required to file a patent application, and what is non-patentable and patentable invention. Okay,
Okay, sir. Yes, we will have a 10 minutes break.
okay, ma'am.
Yeah, yeah. After that, we will join.
Sure. Thank you, ma'am.
But yes, yeah.